Well, good evening, everyone. Welcome to this webinar focused on the importance of preparation of wills and managing estates. By way of introduction, I'm Paul Batchelor, an OA having left in 2000. I'm a partner at Knights, which is a full-service law firm with 22 offices across the country, including close by Abingdon, in Oxford, Newbury and Cheltenham. But in other offices around the country as well. Personally, I specialise in corporate mergers and acquisitions, in particular working with high net worth individuals, family offices, companies and private equity clients as they sort of acquire or sell businesses. So I regularly work with them as they prepare for sale, which is usually a hugely significant event in their lives. And they put a lot of time and effort into that preparation. However, surprisingly, lots of people don't put much preparation and planning into another significant event of their lives, being their death, both in terms of what happens to the estate, the children and dependents, but also how to manage inheritance tax, make charitable gifts, or transfer wealth to the next generation. So it sort of affects everyone. So because I'm not a will specialist, and I'm joined today by my private client partner Erica Burt-Moore, who's a specialist in advising clients on wealth protection matters, wealth protection strategy, later life care arrangements, lifetime tax planning, the use of onshore and offshore trusts, and drafting of wills and lasting powers of attorney. By way of structure, Erica will first cover a few areas that have been highlighted that people want to talk about, and we'll be putting your questions to her at the end of her sort of introductory discussion. And thank you to those who have already submitted some great initial questions. But if you want to ask anything during the webinar, feel free to use the chat function. I think that will just go to the panelists. But just to let you know, the video is being recorded, so obviously we're not going to say anything controversial or confidential on the Q&A, but do bear that in mind that it is being recorded and will be circulated afterwards. We'll aim to wrap up the webinar between 6:45 and 7, with a hard stop at 7, depending on the number of questions we have at the end. So without further ado, I'd pass over to Erica, who can tell us all she knows.
Good evening, everyone. As Paul said, my name's Erica Burt-Moore. I'm a solicitor and a partner at Knights. And yes, my day job is to talk about all things death, dying, planning, tax, things that affect us all, really. So yeah, thank you for your questions that you've already sent in. I am going to be talking about many topics, and hopefully we'll be able to answer most of your questions in the following discussion. So let's get started with so the importance of making a will, when to write a will. So really, all adults with assets should make a will. Assets and children should make a will. A common misconception is, oh, I'm married, I don't need to make a will, everything will pass to my spouse. That is not the case. For example, if you leave it to chance and you're married and you have a spouse has assets in their own name, they will not automatically pass to your spouse. Joint assets do. So if you own a property jointly, that will. If you have joint bank accounts, that will. But if you have assets in your own name, so you've got a second property, you've got an ISA, you've got other investments, it will not automatically pass to your spouse. Intestacy will kick in, and intestacy gives what's called a statutory legacy. So only a certain amount of money and assets will pass, that being 270,000. Anything over that amount will be then split between any children and your spouse again. So it's just messy. It's messy. So it's much cleaner to have a will. The other reason to have a will is that you are able to appoint executors. So executors being the people who will manage your estate after your death. They will notify everybody that you've died, they will arrange your funeral, they will collect in your assets, and they will distribute them according to the will. Let me give you another example. So you aren't married, but you have a child, you don't have a will. rules of intestacy will say that your estate will be left to your child, but without a will, you haven't appointed an executor. Your child is a minor, so they're unable to deal with the estate themselves. So the most appropriate person to deal with the estate would be that child's other parent. Now, if you're no longer with that other parent, would you want that parent to be dealing with your assets on behalf of your child? Now, it'd be great if you did have an amicable split, but if not, I'm sure that would not be the case. So another reason to make a will. Guardians. So parents of a child die at the same time or die when the child, like I said, is a minor. Who would you like to look after that child? So guardians is a different role to the executor. Guardians are the people that will care for your child, provide daily welfare, feed them, clothe them, take them to school. Different role to the executors. It can be the same people, but you can see how crucial that is to make a will, to at least give that indication as to who would be looking after your minor children. I hope that covers why you should make a will. So what can we do with that will? So I've already touched on the fact that we can appoint guardians, we appoint the executors, but let's talk more about the benefits of making this will. So a lot of the questions have been around asset protection. Now I will cover asset protection and I will also cover inheritance tax. So what do I mean by asset protection? Protecting your assets from going to third parties. So you make a will, you leave everything to your spouse, for example. Spouse then goes into a nursing home, spouse becomes bankrupt, spouse remarries, or even spouse is a second spouse. Second marriage. So you're concerned about children from a previous relationship. So there's lots of vulnerabilities around doing a will and leaving everything to your spouse outright. So your spouse, like I said, bankrupt, all of the assets have gone to your spouse. Trustee in bankruptcy will take all of those assets. There isn't then anything to pass on to any children. Surviving spouse goes into care. Again, all of the assets are in that spouse's name. It will all be assessed for care fees. Surviving spouse remarries, makes a new will, leaves assets to new spouse. Children from that first marriage, again, get very little or don't get anything at all. So the use of trusts is how we protect those assets. A really common trust that we do at this stage, so when we've got a first spouse dying, instead of leaving everything to the surviving spouse and leaving them very vulnerable to those events, we can put something in place called an IPD, which is an immediate post-death interest trust. It's also known as what we call a life interest trust. So what we do is we put the assets of the first spouse to die into a trust. And this would be anything that isn't a joint asset. So this would be those ISAs, anything the spouse has in their sole name. It could also be half of any main residence. So you could own your property 50-50, and it could be half of that house. We put it into the trust and we make the surviving spouse the primary beneficiary, meaning that that surviving spouse will continue to take an income from that capital. They will be able to continue to live in the property. So then we look at those events I've already mentioned, such as spouse remarrying, spouse becoming bankrupt, spouse going into nursing care. The assets that the spouse then has are the assets in their name, not the assets of the trust. They would not be considered as their assets when working out their finances in any of those events. So going back to that example where you have children from a previous relationship, what you would do is you would say, right, my assets will go into that trust. My spouse is the primary beneficiary of the income and of any right to live in property, but the capital on my spouse's death will go to my children. And it doesn't have to be children from a previous relationship. It can be children that you have together, but you can see the benefits of doing that and that you know that your children will get something. We don't, however, want to make the surviving spouse in a difficult financial situation. So the will can be written so that the surviving spouse can access the capital if they need to access it for home improvements or any change in financial circumstances. alongside that trust, we do a letter of wishes that will explain how you would like the surviving spouse, to use that trust when they can access capital and when you would prefer that they didn't. The trust is run by trustees, a different role to executors. This is a long-term role to manage this trust. You would normally have the surviving spouse as one trustee and a trusted friend, colleague, professional as a second trustee. Protecting assets on the death of both parties, or at the point where you're passing assets down to children. For most people, they'll say to me, it's a division. I've got 3 children, let's split our estate 3 ways. Absolutely fine in theory, but if your children are minors, they obviously can't inherit until they reach an age that you've specified, such as 18, 21, 25. However, even at 25, they may not have that level of maturity to deal with those assets. So we can do a trust that protects them in a more long-term way called a discretionary trust. So we would set up a discretionary trust for the children. They have no automatic right to any capital or income, and it is run at the discretion of the trustees. The trustees would be, again, your choice, trusted friends, trusted colleagues, professionals, maximum of 4 really. And again, we would do a letter of wishes. It would explain why you've set up the trust. The trust is very, very flexible. The trust can loan money to your beneficiaries. So if your children reach the age that they want to get on the property ladder, the trustees can loan them money. They can purchase a house. If they're in a relationship and the relationship breaks down and the trust provided that deposit, there's no risk of losing that deposit. It's a loan from the trust and must be returned. If the children are married, it protects from divorce. So they would take, again, a loan from the trust. In a divorce, anything they loan from the trust must be returned to the trust, so would not be divided in any divorce scenario. Those kind of trusts we also use for vulnerable beneficiaries or disabled beneficiaries. We do have special trusts for disabled persons called Disabled Persons Trusts that pick up specific tax benefits, which I won't go into too much detail about this evening. If you've got children who are particularly bad with money, have any kind of difficulties, like I say, any kind of vulnerability, then the trust doesn't have to loan them money. The trust can actually purchase a house owned by the trust and they can live in that property. The trust can directly pay for things for them, again, so that there's no risk of them being taken advantage of. So that's an explanation as to how we can do some asset protection. Let's move on to some tax. So inheritance tax. So inheritance tax is primarily a tax on death. There are also occasions where you can be taxed during your lifetime for inheritance tax. There are also exemptions that can apply. So there is an exemption called spouse exemption. So assets that you leave to your spouse are exempt from tax, from inheritance tax. Just touching back onto the IPD that I mentioned, that immediate post-death interest trust. Because you make your spouse the primary beneficiary, spouse exemption does still apply for inheritance tax. Anything that you leave to your spouse outright is also free from inheritance tax. So are any gifts to charity, which I will come back to. Passing money anywhere else apart from your spouse or to charity will be subject to things such as the nil rate band. So the nil rate band for everybody is 325,000. If on the death of a first spouse, they passed everything to their surviving spouse and didn't use their nil rate band, it can be transferred on the death of the second spouse. That's called the transferable nil rate band. So we can have up to 650,000 to apply. So £650,000 free of tax. And then the tax percentage over that is 40%. Further exemptions, the residential nil rate band. The residential nil rate band is quite a complex piece of legislation, but it essentially says that if you leave your main residence to your direct descendants, you will get another £175,000 exemption per spouse. So if you take that with the transferable nil rate band, you could get up to £1 million on the death of both of you, tax-free, and anything over that is taxed at 40%. We start to lose that residential nil rate band if your estate creeps over 2 million. It's slightly tapered, and over 2.2 million, we lose it altogether. There are some complexities around using that tax exemption and also using the discretionary trust that I've already mentioned. And this will be whether it's right or not on a case-by-case basis. But what we're tending to do is still using discretionary trusts and mentioning in your letter of wishes that if it's right to do so, we can take that property out of the trust to claim that residential nil rate ban. Further exemptions, we have business relief. So if you have a qualifying business, this is essentially a trading business that is not involved in investments, then you can also pick up 100% relief on those business shares, or 50% depending on the type of business, your shareholding and the assets. And that's something that we would take advice from your accountant and make sure that it is structured so that we can pick up that relief. There's also agricultural relief. Again, lots of boxes to be ticked with this, such as the farmhouse, how the farm is run, who's working on the farm, farming tenancies. But again, we can pick up a relief which could be 100% relief. So it's really important that if you have businesses and farms that you take advice, take professional advice so that we can pick up these exemptions correctly. And you know, we need to mention this in your wills to make sure we pick up these exemptions. So gifts to charity are tax-free. So gifts to charity during your lifetime, tax-free. If you choose to give a gift to charity on death, we can do that in your will. And that gift, of course, is free of tax. So if you do have a taxable estate, then it will reduce the size of your estate, so the tax bill is less. If you are thinking of being quite generous when it comes to charitable giving, if you give 10% of your residuary estate to charity, it reduces the amount of inheritance tax, or the percentage rather. So instead of 40% tax, you will pay 36% rather than 40 if you leave 10% of your residuary estate to a charity. Now, residuary estate is what's left at the end, basically. So you may have specific legacies, specific gifts, and the pot at the end, once the liabilities have been paid and all the pecuniary legacy specific gifts have gone, 10% of that pot goes to charity, which is tax-free. And then the remainder amount, anything that's over those tax thresholds, will then be taxed at 36%. During lifetime, you've got the 7-year rule, which people have probably heard of. So if you give lifetime gifts, so if you give a gift to a non-exempt beneficiary, such as a child, a friend, anybody else, if it's over £3,000, which is the limit on gifting per year, you have to live for 7 years after that gift has been made. Otherwise, the value of that gift falls back into your estate. It's really important with gifting during lifetime. So a common question I have from clients is, I want to gift my main residence to my children. This will not work. This is called a GROB, a gift with reservation of benefit. If you give something to somebody but continue to use it, it is not a real gift, and therefore it will still be taxed on as though it is yours on your death. If you choose to gift during your lifetime, it has to be given. You cannot retain any benefit from that gift. So it's a really, really big decision. It doesn't have to be a gift outright. We can also use lifetime discretionary trust to retain some control over what you're gifting. For example, 2 children, but like I say, you cannot retain any benefit from that. So a legitimate lifetime gift is called a PET, which is a potentially exempt transfer. So it's potentially exempt. It's completely exempt when we go over that 7 years. There are smaller gifts you can make. You can give £250 gifts. Like I say, you've got £3,000 you can gift per tax year per person. Not if you've got several children, it's got to be £3,000 in total. So let's move on from tax. Lasting powers of attorney. So we talked a lot about death. Lasting powers of attorney are documents that come into force during your lifetime, and they are primarily used should you become physically or mentally incapable. There are two different kinds, one that deals with your finances and one that deals with your health and welfare. The financial one allows you to appoint attorneys. So your attorneys will be people over 18 and people responsible who you trust, never been bankrupt or have a criminal record, basically are good with finances. You appoint your attorneys on this document, but you retain control. The document is registered at the Office of the Public Guardian, which is part of the Court of Protection, and essentially says, in the event that I'm unable to make decisions for myself, or I'm physically incapable of, say, getting to the bank or talking on the phone, then this person has authority to manage my finances. It could also be for nice reasons, such as you're going on a round the world cruise for 12 months, you're not here physically to sign. It allows that person to move your money around, do anything that you could do financially for you. It does not give the attorneys the right to gift to themselves. So, you know, a common appointment of attorneys are your adult children. It doesn't mean that they can then just transfer the main residence to themselves, gift themselves money. They're prohibited from doing that under the law that governs these documents. Like I say, you are in control whilst you have capacity. If you lose capacity, the attorneys will take over and act in your best interests. These documents cannot be used until they've been registered. And registration means that they are then done, set in stone. We can't amend them. So there has to be some longevity to the thinking with these ones, rather than with the will. We can change that over and over again as long as you have capacity. With lasting powers of attorney, once they're registered, that's it. If you change your mind, they'd need to be revoked and we'd need to make new ones. The health lasting power of attorney allows you to appoint, again, adults that you trust to make decisions about your health and welfare. These will only kick in, however, if you've lost capacity, unlike the financial one that could be used when you've got capacity, but you're not here present in this country to make those decisions. So the health one allows you to put guidance on about life-sustaining treatment, for example. So many of my clients will say, I do not want my life to be sustained if I have no quality of life. I would like to have care at home rather than going into a care home. And it's really important, especially where you've got a big family or you've got children that perhaps you don't see, or, it just controls a scenario, a hospital scenario where you might have family members who would disagree about your treatment. So it allows you to appoint the people who would be making those decisions and also give them some guidance. I would recommend those for everybody. It isn't just an age thing. People think, oh, well, I'm not that old. I don't need a power of attorney. It's not always something like Alzheimer's or dementia, that may happen to you. It could be something like a stroke that's very sudden. It could be an accident. And you just haven't then got the time to prepare it. So that the time to do it is now, to have that in place, ready and waiting. Okay, so some mistakes that people made, or some common misconceptions and how to avoid them. Cohabitees is one. So we live in a world now that not everybody is married. It's just not the thing. So we have many people who cohabit. Although the law starting to recognise cohabitees, for wills it really doesn't. So if you die without a will, you've been in a long-term used to be known as a common law marriage. So you're together but not married. That cohabitee has no rights under the law at all. They do have a right under a piece of legislation to make a claim on your estate. But say if you've had children together, they would essentially be claiming against your children. So it's a very, very messy scenario, which can be sorted out, but it costs a lot of money to do that. And it's a sad scenario anyway, without having to get a lot of legal advice and and documents in place to try and sort that out. Now, excuse me, there is a document that we can put in place called a deed of variation. This varies someone's will after they've died. Now, many people will say to me, how is that right? How is that legal to do a deed of variation? If you are a sole beneficiary, so under an intestacy or under a will, and you would like to change that, you would like to put a trust in place instead, or give some money directly to grandchildren or children, we can do this document. You have 2 years following the date of somebody's death to do it. And it allows us to say, put the trusts in place that I've already mentioned, so an IPDIA discretionary trust. And we do these are quite common in, say, you know, your parents' generation that have made simple wills. You perhaps don't need to inherit any more money because you've already got a taxable estate. We can do a deed of variation, vary parents' wills to control that money, put it in a trust for you to access, completely divert you and send it down to the children. So people will often say, you know, I need a watertight will, or I need it set in stone. This isn't possible. Wills, you know, wills can change, the law changes, that they're documents that we need to review, and we review at least every year to 2 years to make sure they're still fit for purpose. I do always say that when you're making a will, write your will as if you're going to die tomorrow, which is a really cheery thought. But if you've got, you know, the guardians are the right choice now, the trustees are the right choice now, your executors are, and that's who you should go with. And as long as you keep reviewing that will, we can continue to control and manage everything that life throws at you. So just to go back to charity. So if you were thinking about charitable giving, there are some terminology when it comes to charitable gifts and gifts in general, really. So, for example, if you were considering a gift to the school, you could do that by a pecuniary gift, so a specific amount in a will. So to the school or to any other charity. So I give £5,000, or, you know, a specific amount. You can give a specific gift. So you could give a vehicle, you could give jewelry, a painting, anything like that you can give to charity. Again, the value would be tax-free. A residuary gift I already mentioned, which would be that pot that you're left with at the end, where you, if you chose to give 10%, it would reduce the tax percentage to 36%, but it doesn't have to be 10% if you don't need that 36%. It could be any percentage of your estate, which is a residuary gift. Or you can do something called a conditional gift, which would be, you know, I give a certain amount on the condition that, you know, my estate is worth over £1 million, then, you know, that charity would get X amount. So there's a condition attached to it. Or I give that certain amount on the condition that it is used for a specific purpose, such as upkeep and repair of a building, that it would go to a specific type of sporting club. So various options. Now, if you've got existing wills and you wanted to add a charitable gift, you would need to do this using a codicil. So it doesn't mean a complete rewrite of the will. It does, however, mean a specific document that is executed like a will. So a will has to have 2 witnesses. They have to be together at the same time. The codicil has to refer to your will, and I would advise and stress that you get that done professionally. If you haven't got a will at all, see, that could be included in your will. Or if you've got old wills and you think, I've not got any of this planning in, then that's something that can be reviewed and then potentially added. If you don't feel like a charitable gift is right now, then again, something we can look at when your will is regularly reviewed. Okay, I've probably talked enough at you, so I'm happy to take some questions, Paul.
Yeah, no, that's great, Erica. I've got a few questions that have come in on the Q&A, and obviously we had some questions that were submitted beforehand, which was really helpful. The first one, I suppose, is a tongue-in-cheek. It's an interesting one. Is, do I actually need a solicitor to draft a will?
Okay, so you don't. Everyone's probably been to a well-known local stationer, high street stationer. and you'll see that you can pick up a make your own will kit. The danger of that is that you've not taken any professional advice. You don't know if it's been executed properly. You don't know if it's been written properly. So although you can, I would always say take professional advice.
And I think as a follow-on to that, what would you say are sort of life events when you should be thinking? So everyone will put a will in place, but are there specific life events that should be triggering you to think, do I need to update or amend my will?
Yeah, so absolutely. So buying a property, buying a property, you need to know where that's going to. If you're a single person and buying a property, again, rules of intestacy will apply. So do you want it to go back to your parents? Do you want it to go to your siblings? Do you want it, where do you want that to go? If you're buying a property with somebody else, it's really important that you know how you own that property. If it's something that we call joint tenants, the property would pass automatically to the other person. Is that what you want? If not, you need to own it differently. The will specify where that goes. Other life events, having children, as I've already mentioned, for the guardians, who would be a trustee of their money. So really important if you've got children to make sure they're well cared for, well set up. Death of a loved one, death of a parent, and inheriting money, because there's so much planning we can do around that when it comes to inheritance tax. So yeah, I always say, or if you're purchasing another property, where does that fit into the will? You're getting divorced. Actually, I didn't touch on that. So if you've got a will and you marry, it revokes your will. So if you are in a relationship at the moment and you're thinking of getting married, you can still make a will, and you make it in contemplation of your marriage. So it basically means that the marriage then will not revoke the will, but it does need that special clause in the will. And the effect of divorce on a will is it's as though that spouse that you've divorced has died. So it doesn't revoke the will is still valid, but it has, like I say, the effect that that spouse has died. So I would still suggest that you get it reviewed.
And I think sort of as a follow on to that, and I know that we like to kill people and destroy their families and get people divorced, but it's the way of actually working out that they work properly and they're fit for purpose. But how does a client manage the situation if they remarried, have children from their first marriage, and they want to ensure that their current spouse is looked after, but that their children are not ultimately cut out of the will? So if everything went to the second spouse, that they don't amend their will to then divert it to the dog's home or to their own children.
So definitely, if you're in that situation, take advice. It will depend on the size of your estate. So in this country, we have testamentary freedom. You can leave your estate to whomever you choose. However, there are certain people who would be able to claim. So if you decided to not leave your new spouse anything and leave everything to your children, new spouse will be able to claim on your estate. And I say that would get messy. So this is where you do need professional help to balance that and manage who's getting what. So often we use that IPD trust that I mentioned. So we would put, for example, if your house is your biggest asset, you would put your half of the house in trust for the children. So you know the children will get that. But of course, we don't want to kick the spouse out. So we say spouse can live there for the rest of their life.
Yeah.
But they cannot sell that, they cannot sell the property and take the capital. We can still allow them to sell the property and move around if they need something more suitable. But the capital in that half will go to the children.
Okay. And we've got lots of questions, and we've had lots of questions around if you've got assets that are sort of held overseas, such as a holiday home, do they fall within? I know it's a very complicated question, but do they fall within the UK estate? And will you have to follow the laws of the location that they're located in, or is there a danger that you can pay tax twice?
Yeah, absolutely. So as I've just mentioned, so in England we have testamentary freedom. So you can leave your estate to whomever you choose. Sadly, this is not the case in many countries, such as France, such as Spain. So if you have properties overseas, whether it be timeshare, holiday home, you know, you sort of live in between, it's really important that you take advice about what will happen to that asset in the country that you have that property. As a general rule, if you are domiciled and resident here in England, you will pay tax on the value of your overseas assets. So you will pay inheritance tax. The will probably not control where the asset goes, but you will certainly pay tax on the value of the asset. It's really, really important to take advice in the country where you have that that property.
Yeah.
And it may be that you are advised to make a will there. Great. You need to then tell your lawyer here that you have an overseas will. We have to mention it in your English will that you have a second will, because otherwise one can revoke the other. So it's really important that we say, right, this is my English will, it deals with my English assets. I have, for example, a Spanish will that deals with my Spanish assets.
Okay. And does it, and talking about sort of overseas assets, or is there's a question coming around overseas family and beneficiaries? There's nothing to stop people from giving assets to people that are outside the UK, is there?
No, no. So giving English assets to people overseas.
Yeah, yes, indeed, yeah.
Yeah, so I would say it's more about the beneficiary taking advice as to how it will affect them. So, for example, there's very complex rules in the USA when it comes to tax. So that would be something that we would, you know, you'd need to take advice on before you transferred anything to someone overseas. But yes, you can do it, absolutely.
And there's an interesting question that I don't know the answer to, but it's from an anonymous attendee, so obviously don't want to be say who they are, but I understand that ongoing trusts are subject to IHT every 10 years. So do trusts created by a will, are they subject to that future tax and admin, or is that separate from that?
Yeah, so I didn't touch on that when I explained about discretionary trusts, because I didn't want to overdo it on this webinar. But yes, a discretionary trust, they do pay tax. They're a separate entity, so they will still pay income tax, they'll pay capital gains tax, and they do pay inheritance tax. They pay roughly, it's quite a complicated formula, but it's roughly 6% of the value of the trust every 10 years. So when you work that out, it's still much better to pay 6% every 10 years than to pass that wealth down to a generation and pay 40% again and again.
Yeah.
So as long as you manage that trust well with your trustees, it's quite easy to account for and plan for that 6%. In fact, HMRC call it an anniversary charge, which is quite a nice word for a tax, really, but it's a 10-year anniversary charge, and like I say, it's roughly 6% of the value of the trust.
Okay. Well, a couple of questions that relate to lasting powers of attorney. I think I know the answer to one of them, actually, but in terms of registering lasting powers of attorney, that's something that actually takes quite a long time, sort of up to half a year sometimes for it to be registered, doesn't it? So it's not something that you can just, if you are going on that world cruise, you need to think about it quite a long time in advance, because you wouldn't be able to use it until you've actually had the power of attorney registered. Is that correct?
Yeah, so from a capacity point of view, as long as you have capacity when you sign it, even though it's not registered, if it's in the process, it doesn't matter. But unfortunately, there's a real backlog at the moment at the Office of the Public Guardian, and it can take weeks to get one through registered. That's why, you don't wait to be diagnosed with something. Don't wait for an illness. If you're an adult, you have assets, just have, get some lasting powers of attorney in place.
Yeah, I have a very personal experience of this recently. So my father-in-law was very poorly over the summer, and over many years we've been thinking we should do it, but they didn't want to do it because they sort of thought he was going to live forever. And we put those in place over the summer, but actually they've not even come back yet, and he passed away a month ago. So actually it is an important thing just to think about. It's not, you're not trying to kill people or say people are going to go anywhere. It's just something to have in the back pocket, so it's sorted. And I suppose there's another question from an attendee that said that they put in place EPAs in 2007, do they need to now redo them as lasting power of attorney, or will they still be effective?
So enduring powers of attorney are still valid, and they're a little different from lasting powers of attorney. So they can be used without registration as long as you have capacity. If you've lost capacity, then they need to be registered at the Office of the Public Guardian, which is a different process to the lasting power of attorney registration. It's a little more complicated in that you have to notify, I think it's 5 of you, your close family members, but it's a little different. So yes, they are still valid. Sometimes when they were set up, the restrictions were put on them. So it's worth reviewing them. And it may be that, yes, you want to sort of upgrade them to a lasting power of attorney, get it registered now so you don't have to go through that process. But yes, they are still valid.
Okay. And I did some, when you were explaining the benefits of sort of making charitable gifts, I was just doing some sort of fag packet calculations here. So it's certainly not guaranteed that it's correct, but I was sort of, if I was working out that there was £1 million left over that was subject to IHT, for example,
yeah,
at the moment it would get £400,000 worth of inheritance tax that would have to be paid out of that. But if there was to be a 10% charitable gift that would bring down the £1 million to £900,000, what that actually has the effect of, it means that the 40% is now down to 36% on the 900. So I think that the actual inheritance tax would be £324,000. So essentially, my way of thinking about that is that you can give a for the cost of sort of £24,000, you're essentially giving a £100,000 gift. Is that very broad brush? But
yeah, that's accurate.
And it sort of feeds into another one of the questions that they had about charitable donations. And how would you actually, you touched upon it, would you would amend the will, so you would actually have to sort of formally document it? How do you know what the will's the organisation is going to do with it?
So the will, or
the charitable
no, sorry.
So the charity, if you, I mean, I imagine lots of charities have got sort of guidance around it, and they can actually sort of say what you can, or whether you can give them an indication as to how you want it to be used.
Absolutely. So most charities have got a lot of information about gifting in wills and the best way to do this. A lot of charities are really also very grateful if you tell them that you've left something to them, because it helps them plan. But yes, you can be quite specific about what your money is used for. But I would always say take advice on that, because it can the clause or the gift could fail if you try and be too specific. So it's always best to get advice. But like I said, most charities have got really good guidance on this. And for example, like I think I touched on, you could say, my money is to be used for the upkeep of a certain building, to go towards like an annual trophy for this, for the rugby team, or so you can be really specific, and that's really nice to know where it's going to go, rather than just into the pot and paying admin fees, for example. Yeah,
and I mean, I know that there's certainly, looking at the Abingdon website while I was waiting, there is actually a legacy section of that, which will sort of explain sort of what you can give, what it goes towards, and how you go about doing it. So I'll ask Harriet when she follows up with the recording and our contact details to include those details, just in case, because it's quite useful to sort of have a look at that. Just having a look through the questions, I think we've managed to pick up the questions that were asked live. We're just seeing if there's anything else in the questions that were asked. No, I think we've done that one. If you've got you touched upon it earlier, if you've got a child that has learning difficulties or is disabled, can you just sort of explain again sort of how you would make provision for them, and who would, how you look after them after you pass away?
Yeah, absolutely. So if you've got a vulnerable beneficiary, If they are registered as disabled, then you can set up a disabled persons trust, which has special tax treatment, so it doesn't pay that 10-year anniversary charge, for example. If you've got a beneficiary that is vulnerable, just needs some help, so we use a discretionary trust. The great thing about these kinds of trusts is that the money will go directly to their needs. So if that vulnerable beneficiary happens to be on state benefits, specifically means tested benefits, if you were to leave money to them, all of those benefits would stop. So by using a trust, it means they can continue to have that stability of those benefits, and the trust would be used to say, take them on holiday, for new clothes or a television, or, you know, additional things to help them. Just out of interest, I am actually on the panel for MenCap. So I'm, you know, people come to me from all over the country have been recommended my services, as I specialise in vulnerable and disabled person trusts.
Okay, well, I think we've picked up most of the questions. Some more things are coming through. Someone's connection actually fell through around the making regular gifts, and so just to reiterate that point, if you make gifts, you can make up to £3,000 a year to anyone, and that won't fall within the inheritance tax, but anything over and above that would fall within the 7-year. What happens if you died after 5 years, for example, after giving someone £10,000, for example?
It will all come back in. So there are some rules. There are some rules, some taper rules, but this is where you give over your nil rate bands. If you give over 325,000, and there's tax tapers over the 7 years, but it's quite complex, and not many people get into gifting those amounts of money. I don't know whether I mentioned as well, when it comes to inheritance tax gifting, you can actually gift as much as you want out of surplus income, which is tax free. So if you've got, you know, you've got more money coming in than you have going out, that excess amount can be gifted free of tax.
Okay. Well, I've got some follow up. There's a number of questions now coming in, but I think we'll have to a number of them we'll have to sort of pick up afterwards, or if necessary, people can give us a call afterwards to actually discuss some of these points, because I don't want to sort of keep everyone here answering specific questions about particular things, but. If the property is put into trust, will the trust be responsible for getting the so if the property is put into a trust, so will the trust be responsible for getting tenant collecting rent instead of the beneficiary? So I suppose that the answer is yes, isn't that?
Role of the trustee. Yeah. There's nothing stopping the trustee from appointing a management, you know, agent to do that. If there's an investment property in the trust, the trustees, yes, are responsible for. They would own that property, but like an owner, could have someone, a third party in place, managing that trust for them.
Okay.
Sorry, managing that property for them.
Okay, and there's another question around, if you didn't have anyone that you would want as a guardian, or at this stage known as guardian for your children, or you're unsure as to who you can make guardians, what are the options? Can you appoint a number of people to decide who's best at the time, or how would you approach that if you really didn't know who they were going to be, or you didn't have anyone? How could you safeguard them without knowing that?
You know, in a sort of worst case scenario, if you haven't appointed guardians, or you appoint a number of people, you would hope that a family member would come forward and say, I will look after this child or children, but ultimately it would be for a judge to decide. So if there were difference of opinions and almost an argument over who should care for these children, it would be put before a judge and they would decide. I mean, and obviously, absolute worst case scenario, those children would be taken into care.
Okay. Well, I think so we've got a number of additional questions coming in, but I think it would be useful to actually sort of draw a line under that so that we can wrap up in time. Of course, I mean, all the questions were quite specific, so we haven't been able to pick up all of them. So if there's any more in-depth conversation, then Harriet will send around the contact details together with the recording of this to those afterwards. And so obviously to remind people that, so as I mentioned earlier, Knights is a full-service law firm. So if you do have any legal requirements other than anything to do with it, sort of personal or business related to things, then do not hesitate to get in touch. And finally, I'd like to sort of thank Harriet and the OA team for asking us to put this on. I hope people have found it useful, and of course we very much welcome if anyone has any specific follow-ups or they need any further assistance, then don't hesitate to get in touch. So Harriet will circulate the recording of this together with our contact details following up from this webinar. So thank you very much, everyone, and have a good evening.